Sixth, ably represented by His Majesty's advisor, Mr. Abdul Latif, my colleague, the Honorable, the Minister of Justice of Morocco, Mr. Mohammed, the President of the Council of Judicial Powers of Morocco, Mr. Mustafa, the heads of the Presidency of Public Prosecution, distinguished colleagues of mine at the Federal Executive Council, the Ministers of Justice and Attorneys General, the Chief Justices, judges and magistrates here present. Assalamu alaikum wa rahmatullahi ta'ala wa barakatuh. It is my singular honor and privilege to address this eminent gathering on the occasion of the first International Justice Conference here in the beautiful city of Marrakech. I am grateful for the invitation graciously extended to me by the Kingdom of Morocco under the wise and esteemed leadership of His Majesty King Mohammed VI to participate at this conference. I convey to you all the high regards and good wishes of the government and people of the Federal Republic of Nigeria, and I am convinced that my participation at this conference is a further indication of the deepening of the excellent relations which already exist between Morocco and Nigeria. The decision to organize this conference by the Presidency of the Public Prosecution and Supreme Council of the Judicial Power, in collaboration with Ministry of Justice of the Kingdom of Morocco, is a most worthy initiative, and it is my hope that this conference will ultimately become one of the foremost global legal conferences dedicated to the exposition and proper articulation of topical legal issues. Legal scholarship can only be advanced through process of continuous and rigorous study, and it is important that African countries should devote considerable time and resources to organizing such conferences in order to ensure that our continent continues to make a significant contribution and resolution of global legal issues. Nigeria is a country of over 180 million, where civil law, Islamic law, and customary laws, all of which are codified, operate hand in hand, both in application and operation. In addressing the topic of this conference, which is the independence of the judicial power, ensuring the litigant rights, and respecting the rules of law, rules of justice, we are confronted with a topic which is at the heart of the sanctity of the judicial system. The independence of the judiciary, the right of the parties in both civil and criminal proceedings, and the promotion of rule of law in all circumstances are all intertwined concepts which deserve our due consideration on a constant basis. I therefore believe that the next 2 days promise to be both revealing and exciting as we dissect this topic. All modern societies, no matter the form of government they choose to be governed by, desire that their affairs should be conducted in humane, orderly, and progressive manner that guarantees the basic rights of the citizens, while at the same time emphasizing the overall responsibility of the state to guarantee the welfare and security of every citizen. In the balancing of these rights and responsibilities, the judicial institution has always been regarded as the most potent societal bulwark against the abuse of power and arbitrariness in governance, and has thus helped to foster the belief of the ordinary citizen in the capacity of the state to protect his legitimate interest. It is therefore the duty of every state, as well as judicial powers themselves, judicial officers themselves, to ensure that credibility of the institution is maintained so that it does not lose social relevance. In analyzing the social relevance of the judiciary, the late Nigerian Justice of the Supreme Court, who was revered for his erudition and scholarship, Honorable Justice Chukwudifo Oputa, JSC, in one of his profound literary interventions, succinctly captured the essence of judiciary in sustaining societal harmony in the following words: "The law will have little relevance if it refuses to address the social issues of the day. Legislators make laws in abstract, but the court deals with the day-to-day problems of litigants and attempt to use the law to solve those problems in such a way as to produce justice. In my opinion, therefore, having established the importance and relevance of the judiciary, it is imperative that all measures must be put in place to make it function optimally in a humane and efficient manner. In this regard, certain safeguards must be put in place to achieve the independence of the judiciary. Number one, in the first place, there must be constitutional guarantee of the independence of the judiciary. Embedding such provisions in the Constitution or supreme law of the land will ensure the judicial capacity is not limited by the character of the executive or the sovereign in the office. For instance, Section 6 of the Constitution of the Federal Republic of Nigeria, 1999, as amended, outlines the judicial powers of the courts and thus creates an unassailable platform for the Nigerian judiciary to assert its authority in determining all matters between persons, governments, and authorities in the country, irrespective of the government in office. Secondly, the state must ensure that it devotes adequate resources to the judiciary to make it function effectively, and that judicial arm substantially control its own resources and allocations. This will ensure that the judicial arm does not become a beggarly institution perennially waiting for crumbs to fall from the table of the executive or the legislative arms. In the third place, government functionaries and individuals must commit themselves to the enforcement of judgment and decisions of the judiciary. This is where the political will of the government comes into play. The judiciary becomes important in the eyes of average citizen once the impression is created that its decisions can be disregarded at will without consequences. Where judicial decisions are so disregarded without consequences, the stage is set for social anarchy, which ultimately leads to the destruction of the state itself. In the fourth place, judicial officers must themselves be committed to ensuring that they maintain higher personal and institutional standards of integrity and uprightness in judicial institutions, if judicial institutions are to be accorded their due respect by citizens. It is a truism that a corrupt judge is more dangerous to society than an incompetent judge. The judiciary must therefore embark on regular self-cleansing, and judicial officers alleged to have contravened the law must be made subjects of judicial proceedings, as we have done recently in Nigeria. Finally, we must realize that the judiciary cannot work in isolation of other institutions and agencies of government. Therefore, reform measures within the judiciary must be complemented by progressive improvements in the capacities of the agencies responsible for investigation and prosecution of cases before the courts. In this way, the judiciary will be a better place to determine cases before them on a pedestal of merit and full facts. Your Excellencies, distinguished ladies and gentlemen, litigants before our courts and judicial and quasi-judicial institutions will ultimately feel safe and comfortable in the power of judiciary when they are aware that the judiciary will always act in the public interest, do justice in a fair and equitable manner, and are assured that the decrees and judgments of the courts will be obeyed by all functionaries and institutions in every jurisdiction. It is therefore our duty as administrators of justice in our various countries to ensure that we create conditions that will engender higher levels of confidence by litigants and the general citizenry in the judicial process. It is also necessary at this juncture to urge that this conference this year or in its future editions should devote adequate attention to the evaluation of current policies guiding the minimum performance benchmark for judges and staff of the judiciary in our various jurisdictions. Judges must see themselves as servants of the people and demonstrate that consciousness in the manner they conduct judicial business. It is equally necessary to encourage judicial officers in appropriate cases to ensure that personal and private rights are not unduly emphasized to the detriment of collective national interest considerations. In certain jurisdictions, including my country, Nigeria, we have seen situations where private rights of accused persons are unduly elevated even when their alleged conduct has caused enormous economic or financial damage to the country through acts of corruption and impunity. The judicial system must not become a perpetual place of refuge for persons who have willfully acted against the interests of their communities or countries. Otherwise, the ordinary citizen will lose confidence in the rule of law. In the discharge of my duties as the Attorney General and Minister of Justice of Nigeria, I am guided by constitutional limitations of interest of justice and public interest, and no more. In conclusion, let me say that I'm convinced that this conference will achieve its objectives, given the quality of the resource persons and participants here present. I look forward to the objective exchange of views, experiences during our deliberations, and trust that we should go back to our respective jurisdictions with renewed determination to promote judicial independence of the judiciary, the rights of the litigants, the supremacy of the rule of law, and indeed the interest of justice and public interest. I thank you most sincerely, Your Excellencies, distinguished ladies and gentlemen, for this opportunity to address you this morning. Thank you.